submitted that by government letter dated 3/12/1980, the procedure / direction was issued for making appointment of all class 4 posts in district level, and further direction was issued by letter dated 26/5/1987 as contained in Annexure 1 and 2 of the petition. He has further submitted that before the bifurcation of the state of Bihar, the then Deputy Commissioner Devkar on 3/8/1999 inaugurated Nandan Pahar Devkar as a tourist place in Devkar district, and as such appointed several persons, including the petitioners, on fixed monthly wage to look after day-to-day maintenance of park and affairs of Nandan Pahar. By giving the background with regard to the petitioner, with regard to each of the petitioners, the learned counsel has submitted as under. Synopsis से ले लेते हैं. You just come to Roman 2. Petitioner number 1, right? Petitioner number 2, petitioner number 3, and petitioner number 4. The learned counsel further submits that the requisition was sent by the Deputy Commissioner Devkar by letter dated 14/3/2005 for roster clearance of vacant post of class 4 employees, and the Commissioner Santhal Pargana Division by this letter dated 24/3/2005 sent the roster clearance of 50 vacancies in class 4 post in Devkar Collectorate. He submits that the petitioners continued to work, and since 2001, the Deputy Commissioner Devkar has not published any advertisement for regular appointment on the vacant class 4 post in Devkar district, and the petitioners have been working on contractual / daily wage basis against vacant sanctioned class 4 post. The learned counsel submits that a scheme of regularization of persons like the petitioner have been framed by the state of Jharkhand by notification number 1348 dated 13/2/2015 and notification number 4871 dated 20/6/2019 in compliance of various orders passed by the Honorable Supreme Court, and pursuant to such scheme for regularization, the authorities of the state government were directed to take steps for regularization of the persons who are covered under the scheme. The learned counsel submits that the petitioners are being paid the honorarium by the Deputy Commissioner himself and the details of the petitioners and others with regard to payment of honorarium has been mentioned in paragraph 41 of the petition, which is dated 21/2023, and the details of vacant sanction post has been given in page 42 of this writ petition, which is dated 13/3/2021. The Learned Counsel submits that the petitioners filed their representation for consideration of their case for regularization by representation dated 28/8/2022 before the Deputy Commissioner Devkar. But no steps were taken, and therefore the petitioners have filed the present writ petition. They are still working?
Yes.
The Learned Counsel for the petitioners has submitted that the petitioners are still working. The Learned Counsel, appearing on behalf of the state by opposing the prayer of the petitioner, has submitted that in the year 1999, a committee was constituted for maintenance of Nandan Pahad as amusement park and tourist place under the chairmanship of the Deputy Commissioner Devkar, and a committee was constituted by memo number 699 dated 22/4/1999 for the management development and functioning of Nandan Pahad within bracket amusement park. Initially, the management of the said Nandan Pahad was given to private operator to run and manage, which they continued for a period of 3 years, and thereafter the committee itself started managing the said park. And the persons who were engaged by the private persons were continued for the purposes of working in Nandan Pahad Amusement Park on the basis of fixed monthly payment. She also submits that the amusement park is self-financed park and no grant or financial aid is provided for operating the park by the state, and the income received from the entertainment activity, entry fees, etc. are being utilized for the payment of honorarium to the petitioner engaged therein, including the petitioners. She has also submitted that neither any recruitment process has been followed nor any kind of appointment on daily wage / contractual employment / regular employment has been undertaken by the respondent. She submits that the petitioners cannot be said to be employees of the collectorate, and therefore they are not entitled for regularization. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the aforesaid amusement park belongs to the respondents. And it is further not in dispute that the petitioners have been working on payment of honorarium for long years, and they have continued to work, and the honorarium is being paid to them, which is also apparent from the document contained at page number 41 of the writ petition. And the vacancy position in connection with class 4 employees in the collectorate is also apparent from annexure 9 at page 42 of the writ petition. The fact that no recruitment process has been undertaken for the class 4 employees in the Devghar collectorate since 2001 is also not in dispute. Correct?
Regarding this, I have no idea, no discussion.
But it is not disputed in your counter affidavit. Not disputed in your counter affidavit, at least to that extent.
Yes.
In view of the aforesaid facts and circumstances, this court is of the considered view that this court also finds that the petitioners have also filed an application before the Deputy Commissioner Devghar for consideration of their case for regularization as back as on 28/8/2022. This court is of the considered view that if the claim of the petitioner falls under the scheme for regularization, framed by the state of Jharkhand as back as in the year 2015 and also in the year 2019, the claim of the petitioners is required to be considered by the Deputy Commissioner Devghar or the appropriate committee as contemplated under the said scheme. Committee है ना इसमें? There is a committee formed.
Committee has not take the deputy commissioner who gets appointment on class 4 but within his jurisdiction.
No. For regularization.
For regularization, they have to take decision.
They have to take decision by forming a committee.
No, by forming a committee, district establishment.
This court is of the considered view that it is also required to be scrutinized as to the source from which the petitioners are being paid and also under whose instructions the petitioners were continued to work even after the so-called private contractor discontinued to manage the park. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 4 within a period of 1 month from today by filing a representation with supporting documents with regard to their claim, which shall also include the details regarding payment made to the petitioners from time to time and also instructions, if any, issued to the petitioners by one or the other respondents. Upon filing of such representation, the respondent number 4 shall look into the grievance of the petitioner and take appropriate steps for consideration of their claim under the consideration of their claim if they are found entitled for regularization in terms of the scheme framed by the state of Jharkhand in the year 2015 and 2019. The respondent number 4 is directed to pass a reasoned order within a period of 3 months from the date. No, is directed to do the needful within a period of 3 months by passing a reasoned order within a period of 3 months from the date of filing of the representation. The petition is accordingly disposed of.
From the supplementary list, express item 3, WPS 2373 of 2023.
In this case, the order of dismissal is under challenge. But before going to the order impingement, kindly see the charge. What is the exact charge framed against the petitioner? That will clear the picture. But that is page 17 annexure 1. आरोप निलंबित आरक्षी 722 नंद किशोर झारखंड सशस्त्र पुलिस 7 हजारीबाग के विरुद्ध घोर अनुशासनहीनता, कर्तव्यहीनता, स्वेच्छाचारिता एवं बिना किसी सूचना एवं अनुमति के अवकाश से पिछड़ने का निम्नांकित आरोप लगाया जाता है कि नंबर 1, इन्हें वाहिनी मुख्यालय में पदस्थापित रहने के दौरान दिनांक 21/6/18 के अपराह्न से दिनांक 23/6/18 के अपराह्न तक एक बिन आकस्मिक अवकाश +1 एक दिन बंदी कुल 2 दिन का अवकाश उपभोग करने की अनुमति दी गई थी। तदनुसार इनकी उपस्थिति दिनांक 24/6/18 के पूर्वाह्न में वाहिनी मुख्यालय झारखंड सशस्त्र पुलिस 7 हजारीबाग में थी, परंतु ये नियत समय पर अपने कार्य पर उपस्थित न होकर बिना किसी सूचना एवं अनुमति के अवकाश से पिछड़ने लगे। उपरोक्त आरोप के लिए वाहिनी के बलादेश संख्या 788/2018 के अनुसार इनका वेतन निर्धारित किया गया है। इन्हें शीघ्र अपने कार्य पर उपस्थित होने हेतु हफ्ते भर के कार्यालय का ज्ञापांक 1665 दिनांक 19/7/18 एवं ज्ञापांक 2118 दिनांक 25/9/18 के द्वारा निबंधित डाक के माध्यम से पत्र भेजकर आदेशित किया गया, परंतु ये कार्यालय आदेश की अवहेलना कर अवकाश से पिछड़ते रहे। तत्पश्चात इस कार्यालय का ज्ञापांक 2330 24/10/18 के द्वारा अवकाश से पिछड़ने का वास्तविक कारणों का जांच करने के लिए इस वाहिनी के अवर निरीक्षक दुर्गाचरण बारी को, ये दुर्गाचरण बारी है बारी को इनके गृह पते पर भेजा गया। अवर निरीक्षक दुर्गाचरण बारी के समक्ष दिनांक 29/10/18 को इनके द्वारा एक लिखित आवेदन देकर, इनके द्वारा एक लिखित आवेदन देकर अपनी मां की दिमागी हालत सही नहीं रहने एवं उनका मेंटल अस्पताल रांची में इलाजरत रहने का जिक्र करते हुए दिनांक 16/11/18 को अपने कार्य पर उपस्थित होने का उल्लेख किया, परंतु ये अपने कार्य पर उपस्थित न होकर मनमाने ढंग से अवकाश से पिछड़ते रहे, जो एक अनुशासनहीन एवं स्वेच्छाचारी आरक्षी होने का परिचायक है। फलस्वरूप इस वाहिनी के बलादेश संख्या 14/11/2018 के अनुसार दिनांक 19/11/2018 से इन्हें निलंबित किया गया। पुनः इस कार्यालय के ज्ञापांक 25/12 दिनांक 27/11/18 के द्वारा निबंधित डाक से इन्हें निलंबन हेतु संबंधित सूचना देते हुए शीघ्र कार्य पर उपस्थित भेजने हेतु आदेशित किया गया। निलंबित आरक्षी 722 नंदकिशोर का यह आचरण एक अनुशासनहीन, कर्तव्यहीन एवं स्वेच्छाचारी आरक्षी होने का द्योतक है। इनके इस कार्रवाई से सशस्त्र बल के कार्य एवं अनुशासन पर प्रतिकूल असर पड़ा तथा वाहिनी का छवि धूमिल हुई है। ये अभी तक अपने कार्य पर उपस्थित नहीं हुए हैं और न ही किसी प्रकार की सूचना कार्यालय में प्राप्त कराए हैं, अतः विभागीय कार्यवाही प्रारंभ करने का आदेश दिया जाता है। सो मैडम दी नटसेल मैडम दी चार्ज कि although he has given the information, but after expiry of the period, the leave, my lord, he has not appeared and therefore the proceeding. How much the unauthorized absent, there is no specific charge. My lord, why I am pointing out, my lord, because the inquiry officer has given the findings that he has remained unauthorized leave for 286 days. So that is not the specific charge here in the charge memo, my lord. And further, my lord, it is clear from the charge memo itself that one Durga Charan Bari, my lord, one officer of this very organization, my lord, has visited the home address of this petitioner, my lord, and there he has explained the reason for his unauthorized or for not attending the duty or not reporting the my lord, the force within time, my lord, after expiry of the leave period. The reason is given, my lord. So therefore, my lord, very initially I am pointing out the unauthorized or remaining absent from the duty is not willful, my lord. Rather, the compelling circumstances is there, and the reason is shown that because of the mental illness of her mother, his mother, my lord. Therefore, he could not attend the duty and he remained absent for so many days, my lord. So reason is there, it is not willful, my lord, and that reason was communicated. The application in writing was handed over to the Durga Charan Bari, and the officer who visited his own home, my lord. So it is not. So on this basis, my lord, the proceeding was initiated against this. Now, my lord, the annexure 2 is the inquiry report. इंक्वायरी रिपोर्ट का अगर हम दो बड़ी शॉर्ट है, अगर माय लॉर्ड परमिट मी देन आई कैन प्लेस।
देखिए ऐसा है ना कि अगर आप पूरा ऊपर से नीचे तक पढ़ेंगे,
देयरफॉर माय लॉर्ड द रिलेवेंट पॉइंट्स, द रिलेवेंट माय लॉर्ड काइंडली सी द
पूरा चार्ज पढ़ने का कोई काम नहीं था। आपको नहीं लगता है कि हम पढ़ के आए हैं?
हम पढ़ करके
हाँ, तो बस इसीलिए आप अपना सीधा मुद्दा पर आइए।
तो मुद्दे पर आइए।
हाँ, बस।
सो माय लॉर्ड काइंडली सी द
you just there are two orders against you, you just point out the perversity in the
yes,
order.
perversity.
Yes.
Perversity points I am coming, my lord. The perversity and the whether the legal mandates, the mandates of the law of the Supreme Court, my lord, the principle of natural justice, whether these has been followed or not, that will come, my lord, that I will come later on. But the perversity in the order, my lord. My lord, page number 20, the concluding portion of the inquiry report, my lord. It is 7th line from the bottom, my lord. इनके द्वारा स्वयं का इलाज से संबंधित चिकित्सा प्रमाण पत्र दिए हैं जिसमें दवा क्रय का रसीद एवं दवा का रेफर प्रस्तुत नहीं किए हैं। सी द रीजनिंग गिवन बाय द इंक्वायरी, दवा क्रय का रसीद एवं दवा का रेफर प्रस्तुत नहीं किए हैं, जिससे यह स्पष्ट लगता है कि आरोपित द्वारा समर्पित चिकित्सा प्रमाण पत्र, ना माय लॉर्ड, आरोपी द्वारा समर्पित चिकित्सा प्रमाण पत्र आरोप से बचने का बहाना मात्र है। सो माय लॉर्ड, दिस इज बेस्ड ऑन द एजम्पशंस एंड प्रिजम्पशंस ओनली कि सर्टिफिकेट ऑफ द डॉक्टर व्हिच हैज बीन प्रोड्यूस्ड बाय द पेटिशनर दैट इज नॉट रिलायबल। रीजन इज
वो अपने इलाज का बात कर रहे हैं, माँ के इलाज का बात नहीं कर रहे।
हाँ, वो पूरा में अगर जो है तो फिर ऊपर से चलते हैं।
नहीं, आप ही बताइए, स्वयं का इलाज लिखा है तो?
हाँ, लिखा, अगर उस पे भी हम आ रहे हैं, स्वयं का इलाज का भी बात करूं, उसमें ये नहीं है कि माँ वाला को हम कहीं गौन कर दें, माँ वाला भी हम the manner in which the reasoning has been assigned by the inquiry officer, the reasoning is कि हमने वो दवा का जो हम यूज कर रहे थे उसका रेपर नहीं दिए एंड दवा जो खरीद किए कहाँ से खरीदे वो नहीं किए। What I am submitting, my lord, जो डॉक्टर ने जो सर्टिफिकेट दिया कि आई वॉज सफरिंग फ्रॉम सर्टेन इलनेस एंड आई वॉज अंडर द ट्रीटमेंट ऑफ द डॉक्टर and the medicine which was been taken by the petitioner, my lord, that is under the prescription, under the instructions of the doctor. So certificate is more important, or the wrapper or the purchase slip of the medicine is more important, my lord. When the inquiry officer has not displayed the certificate of the doctor, whether the wrapper of the medicine and the purchase slip of the medicine store is relevant, my lord. Which one is reliable? Certainly, my lord, the certificate of doctor is given the priority, my lord. It is not the report. So, what kind of reasoning is given assigned by the inquiry officer, my lord? So, this is not sustainable, my lord, in my humble submission.
That's all.
So, my lord, this is one part of the lacuna in the findings of the inquiry report, my lord. Further thing, my lord, it is an admitted case, my lord, that I have not informed the organization, my lord. Rather, I have informed, and the reason I have given the compelling circumstances that the mother is suffering from the mental illness. My lord, it's more important to performing a duty rather to see a mother who has given the birth to a person, my lord. He has to perform the pious human duty as well as the pious duty of his son as well, my lord. So this duty, my lord, it's a natural duty. Nobody can ignore the mother illness, my lord. It's a pious duty assigned to every human being, my lord, not only the son. It's a kind duty, my lord, to the human service. It's considered to be a human service. How a person can be left? And a special reason has been assigned that I am the single person to look after of my mother, my lord. So this is the circumstance. So this cannot be termed as a willful absence from the duty. When there is a willful absence, only this kind of harsh view or the harsh punishment can be avoided, my lord. So this is one point of submission, my lord. That's why, my lord, I was submitting. Can you permit me to place the inquiry report? It's a 3-page inquiry report.
हम पूरा पढ़ के आए, आपको जो पढ़ना है इसमें पढ़ लीजिए.
Then I will like to place
we will not permit you to read everything from the brief, right? You just read the relevant portion. I've heard you on perversity. What else?
So, my lord, from the inquiry report, the 2 points I am highlighting. The first, the medical certificate issued by the doctors, my lord, the authorized doctor, that has not been deduced. The reason for disbelieving, I have not produced the wrapper of the medicine and the purchase slip of the medicine, my lord. So that is not sustainable. That findings of the inquiry officer is based on the presumptions and assumption कि ये नहीं दिए इसलिए ऐसा सही नहीं पड़ती. So this is not based on the foundational facts, my lord. So foundational facts itself is missing, my lord, and nobody has come to say that this doctor's certificate is forged or fabricated. It is not the reason assigned by the inquiry officer as well, my lord. Now, my lord, the most important point, my lord, which I am taking, my lord, on the basis of the inquiry report, my lord, the disciplinary authority has passed the order, my lord. The order of punishment, my lord, the major penalties have been awarded to the petitioner, my lord. That major penalty, my lord, before passing the major penalty, my lord, it was the bounden duty of the disciplinary authority, my lord, to issue a so-called notice asking the petitioner or the delinquent employee to explain what he has to say on the findings of facts recorded by the inquiry officer. That's why, my lord, had this finding of facts notice would have been issued by the authority, then I have reverted the findings of the inquiry officer which has been purposely recorded in the inquiry report. That opportunity was not given by the disciplinary authority, and what the notice has been issued, my lord, the second so-called notice, my lord, that is against the proposed punishment, not against the finding of facts. My lord, this proposed second so-called notice against the proposed punishment, it was not necessary because it is not mandatory after the 42nd constitutional amendment. What is necessary is to give this notice, my lord, the second so-called notice regarding the defending the findings of the fact recorded by the inquiry officer in the inquiry report. Now, my lord, kindly permit me to place, my lord, this is the annexure 3, my lord, page 21. My lord, kindly see. For appreciation, my lord, for better appreciation. Although, my lord, I know my lord has come after reading
बिना
of the
देखे भी आपको पूरा सुना सकते हैं.
That's why, my lord.
इसलिए आपको ये बात
Yes.
पता होना चाहिए कि हम पढ़ के आए हैं.
हाँ, पढ़ के आए हैं.
तो
Therefore, my lord, my efforts, my lord, to convince, my lord, whether what kind of notice it is. In the notice, in the subject itself, it is mentioned विभागीय कार्यवाही संख्या 16/2018 में विरहत दंड के विरुद्ध. The wording of this notice is, my lord, विरहत दंड के विरुद्ध द्वितीय बचाव स्पष्टीकरण समर्पित करने के संबंध में. My lord, save and accept, there is a no second so called notice, my lord, in which it has been asked by the department to the petitioner that please you explain, the inquiry officer has submitted this kind of findings against you, so what you have to say? You explain your points, my lord, your defense. My lord, this has not been given, my lord. My lord, to revert this point, my lord, one judgment I have read, that is the famous judgment of ECI manager Hyderabad, my lord, 1993 Supreme Court, my lord. That has been annexed along with my rejoinder, my lord. And that point has not been rebutted in a specific term in their counter affidavit, my lord. They have not made any specific comments. That means that is admitted. The contention raised by the petitioner that remains admitted, my lord. They have not rebutted, subject to correction of my friend, my lord, of other side. That I have given a specific statement in my rejoinder, my lord, that the contention made in my petition at paragraph 18 that has not been rebutted. So, my lord, the judgment is, my lord, 1993 4 SCC page 727, my lord. The managing director ECIL Hyderabad and others versus B. Karmakaran and others. My lord, directly come to the paragraph 25 of the judgment. Only one paragraph. Paragraph 25. Yes. Mary. While the right to represent against the findings of the report is part of the reasonable opportunity available during the first stage of the inquiry, before the disciplinary authority takes into consideration the findings in the report, the right to show cause against the penalty proposed belong to the second stage, when the disciplinary authority has considered the findings in the report and has come to the conclusion with regard to the guilt of the employee and proposed to award the penalty on the basis of its conclusion. The first right is to prove innocence. The first right is to prove innocence. So, here in my case, my lord, before issuing this second so cause on the proposed punishment, the authority was bound to issue the second so called notice on the finding of facts where, why, and whereunder I had been held guilty. My lord, admittedly there is no so called notice, my lord, where by my lord the authority has asked me to explain my innocence. That has not been given by the authority, my lord. The second right is to plead for either no penalty or lesser penalty. Now, my lord, the second aspect of the matter, if I have been held guilty, तब हम उस पर प्लीड कर से कि यस इतना पनिशमेंट सही नहीं है. The proposed penalty of dismissal is too harsh. This is my first offense, or this is the first instance of my fault, my lord, or the lesser punishment is wanted because of the various circumstances. This is not. In criminal jurisprudence also, my lord, the first time somebody hold guilty on the basis of the material, that is called conviction, and when the conviction is proved on the findings of the evidence, my lord, then the opportunity of on the point of sentence, which kind of sentence is appropriate, whether it is a case of death penalty or the life imprisonment or the 10 years or whatever, or whether I am the entitled for probation or under the provision of probation of offender rights. So here it is the case as well, my lord. They have issued only on the point of the penalties, not on the point of this my lord, findings of fact regarding my innocence or the guilt, my lord. Except it is the second right exercisable at the second state which was taken away by the 42nd Amendment. So, my lord, this 42nd Amendment, my lord, this was introduced in the Constitution of India, my lord, कि purpose penalty sentence पे देना कोई जरूरी नहीं रह गया डिपार्टमेंटल प्रोसीडिंग में, लेकिन finding of fact with regard to proving my innocence, my lord, that is the one of the fundamental right, my lord. That is the main moot question, my lord, to be decided. That is not followed in my case, my lord. So what they have issued, the second so-called on the basis of the purportments, which was not mandated. If I was held guilty, then they were at liberty to give me any kind of punishment as per their choice. This remains the vital lacuna in the departmental proceeding. Now, my lord, neither the appellate or the disciplinary authority, nor the appellate authority, or not the higher authority to whom I have represented, my lord, they have not considered this aspect, my lord. And this is the Constitution bench judgment, my lord. So this is one of the points, my lord. Now, the another point, my lord, which I have argued, my lord, with regard to the willful absent. My lord, when there is a willful absent, certainly the departmental proceeding, my lord, or the authority concerned are entitled to take the strict action. But when there is no willful absence, my lord, the compelling circumstances is there, my lord, and that compelling circumstances has been shown by me from the day one, when the Durga Charanbari, the some spectre
You are
of the...
again repeating your. Don't come back to
Madam,
the first
that
point. You
I am
have
not
completed
repeating,
your
madam.
first point and I have heard it.
Yes.
You are
Madam,
arguing
madam,
on the
why,
second
why
point
I
and I
am
am
repeating,
hearing.
my lord? Because I have a judgment to support my contention.
You
and
cite
was-
your judgment.
Yes.
But don't repeat your arguments.
Repeating is a must, my lord, at this stage when I am submitting the judgment. The judgment which I am supporting, my
You
lord.
start a point and conclude a point.
Yes, madam. So that is my way of
You cannot
submission.
shift from one point to another point
Here
suddenly.
I will differ with respect, all kind of respect, my lord. This is my way of submission, my lord. My lord is free to pass the order, and I am free to submit as per me, my lord, as per my convenience, my lord. How I will argue, that is my prerogative, my lord, unless and until I speak anything
See,
unparliamentary.
I'm listening to you very patiently.
Yes, my lord.
My only concern,
very
please
patiently, my
hold
lord.
on.
That is
Please
my
hold
lord
on.
past duty, my lord.
Please
and
hold
this
on.
is my duty as well to assist the court.
Please hold on.
Yes.
When you start a point, you should conclude the point with all
Yes,
the
madam,
judgments.
that I am doing,
You
my lord.
cannot
In
shift-
between, my lord, is
you
interfering
cannot shift-
unnecessarily, my lord.
You-
That I can say.
You cannot shift from one point to another and jump from one point to
My
another
lord,
like this.
the very beginning,
So-
the
so
very
your-
systematically,
so your-
my lord.
so
I
your
have
second
concluded
point is
the
complete?
point systematically,
Just a
my lord.
moment.
इस इतना बीच में तो I would have placed the entire judgment, my lord.
Your
I would have
second,
placed.
your second point is complete?
My
या
lord,
उसमें
the
कोई
first
और
point-
judgment देना है?
Yes, the first point, second
Your second point
and now
is
this is the third point. This is the third point which I am submitting.
Okay. First
Supporting
point I have
the
seen, second point also I have seen. What is
Yes.
the third point?
Now, my lord, the third point.
Yes.
My lord, what I am submitting, my lord, the unauthorized absence can only be justified, my lord, and the punishment can only be justified when there is a specific finding that the unauthorized absence is willful. So what I am trying to submit and convince to my lord, that here in the present case, it is not the willful absence from the duty. And the reason I have supplied to the department, my lord, that my mother was suffering from the mental illness, and it's being the only son, it's my pious duty to serve my mother. And in this way, my lord, even the department cannot deprecate my conduct, because it's a conduct, it's related to the good human being as well, my lord. Therefore, my lord, I am relying upon this judgment, my lord, 2012 3SS. The first judgment, my lord, that I have, that has been annexed in the rejoinder itself, my lord, and this is the second. My lord, paragraph 15 to 24 are the relevant, my lord. My lord, can you permit me to please? My lord, better, my lord, the paragraph 17, I should place first, my lord. If the absence is the result of the compelling, paragraph 17, my lord. If the absence is the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application or prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventuality due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such cases, the employee cannot be held guilty of failure of devotion of duty or behavior unbecoming of an absent. So, my lord, what the Honorable Supreme Court has held, my lord, कि when the circumstances of such a nature which compelled an employee to abstain from duty, so this kind of unauthorized absent, my lord, even though, and this is not, I have informed the department, that is the admitted case, my lord. That is my lord, I was placing the inquiry report, especially the evidence of the Durga Charan Bari, to whom I have given the application in writing, and he has admitted in his evidence as well, my lord. It is an admitted case that I have informed him in writing. This is this compelling circumstances. And that is, my lord, this judgment, especially the paragraph 17, my lord, the ratio laid down by the Honorable Supreme Court in this very case, my lord, completely rescue me from the case, my lord. The compelling circumstances is there. So, this is all.
Just respond.
As per the opportunity given, as he's mentioning, the opportunity was not given, ample opportunity was given to him, and he has taken leave for 2 days, as it was mentioned, from 21/6/2018 to 23/6/2018. After that, one casual leave and one permission leave. He had to report back on 24/6/2018, but he didn't appear nor given any information or reason. If he must have wanted more leave, then he would have given for extension for leave, but nothing was given for that. Salary of the petitioner was held up, and again petitioner was informed by post, that was dated on 19/7/2018, directing him to appear, but he didn't appear on that date also. And again on 24/10/2000, continuously the department was sending by post, and after that the sub-inspector of police, as he was mentioning, Durga Charan Bari, and he was given to inquiry the matter. I have already mentioned, detail mentioned in the counter affidavit, your ladyship, and in para 9 we have mentioned that on 29/10/2018 that sub-inspector appeared in his home, and he stated that his mother is not well. He gave that no medical certificate has been annexed in this, your ladyship, and for that he was informed, and he was suspended on 19/10/2018. Annexure A, your ladyship, we have annexed the document. I may be permitted to read.
Yes, you place your case. Yes.
कि दिन रविवार कुल 2 दिनों का अवकाश 21/6/2000 में इन्हीं कार्य पर शीघ्र उपस्थित होने हेतु इस कार्यालय का ज्ञापक 1665 दिनांक 19/7/2018 ज्ञापक 218 25/9/2018 के द्वारा इनके गृह पते अवकाश के विलंब होने के वास्तविक कारणों का पता करने हेतु इस वाहिनी के दुर्गा चरण बारी को दिनांक 27/10/2018, as I've already mentioned in para 8 of the counter affidavit, को इनके गृह पते पर भेजा गया। दुर्गा चरण बारी के द्वारा जांचोपरांत इस जांच प्रत्यंत समर्पित किया गया, जिसके उप आरक्षी द्वारा अपनी मां का दिमागी हालत सही नहीं होने पर एवं रांची मेंटल हॉस्पिटल में इलाजरत रहने के कारण कर्तव्य में उपस्थित नहीं हो सके। 2018 को अपने कर्तव्य में 16/11/2018 को अपने कर्तव्य में उपस्थित होने का उल्लेख किया गया, परंतु उस आरक्षी अब तक अपने कार्य पर उपस्थित नहीं हुए। नंद किशोर कार्यालय आदेश पर अवहेलना कर मनमाने ढंग से अवकाश से पिछड़ने के आरोप में तत्काल प्रभाव से निलंबित किया गया है। In page 28 that was mentioned, and as he was saying, reasonable opportunity was not given. Reasonable opportunity was also given to be heard in compliance of the national justice, Your Ladyship, as we have already annexed the document and it should be. And on 22/7/2020, he was dismissed from service. Kindly annexes C of the counter affidavit. Your Ladyship, as it was his usual habit, page 34 of annexure C of the counter affidavit, where it has been mentioned, the last portion of page 34, आरोपित के द्वारा संचालन पदाधिकारी के समक्ष अपना अंतिम बचाव स्पष्टीकरण समर्पित किया गया है, जिनमें वे अपनी मां का मानसिक संतुलन ठीक नहीं होने तथा घर छोड़कर कहीं चले जाने के कारण मां का खोजबीन करने एवं इलाज करवाने तथा इसी बीच आरोपित अपना नाक का इन्फेक्शन होने के कारण तबीयत खराब होने का जिक्र किया है।
कहाँ पढ़ रहे हैं
आप? पेज 34 लास्ट पैरा
of the
counter affidavit annexure C. He has given small reasons for the long leave, he has unauthorized leave that he has taken.
yes
खोजबीन करने एवं इलाज करवाने तथा इसी बीच आरोपित अपना नाक का इन्फेक्शन होने के कारण तबीयत खराब होने का जिक्र किया है। आरोपित के द्वारा अपनी मां लक्ष्मी देवी का इलाज रिन पास कांके रांची से कराने संबंधित कागजात समर्पित किया है, जो वर्ष 2009 है, तथा स्वयं का नाक में इन्फेक्शन होने का जिक्र किया है, जबकि इनके द्वारा दंत चिकित्सक के इलाज कराने संबंधी प्रमाण पत्र समर्पित किया गया है, परंतु इनके द्वारा दवा का क्रय का पूर्जा समर्पित नहीं किया गया है, जिससे स्पष्ट होता है कि आरोपित के द्वारा समर्पित चिकित्सा प्रमाण पत्र आरोप से बचने का बहाना मात्र है। 2 वर्ष की सेवा अवधि में 2 बार क्रमश 286 दिन एवं 169 दिन कुल 455 दिन अवकाश से पिछड़े हैं, जिसे प्रतीत होता है कि आरोपित एक अनुशासनहीन, कर्तव्यहीनता एवं स्वेच्छाचारी आरक्षी है। इस संबंध में आरोपित पर लगाए गए आरोपों में सेवा से बर्खास्तगी के विरुद्ध स्पष्टीकरण समर्पित करने का अंतिम मौका देते हुए इस कार्यालय ज्ञापक opportunity was given again 11/7/2020 द्वारा पत्र आरोपित को प्राप्त कराया गया। आरोपित द्वारा सेवा से बर्खास्तगी के विरुद्ध दिए गए बचाव स्पष्टीकरण अत्यंत असंतोषजनक है, क्योंकि उन्हें हमेशा अपनी व्यक्तिगत समस्याओं के बारे में वरीय पदाधिकारियों को सूचित करने का अवसर रहता है। अपचारी का आचरण नौकरी के प्रति गंभीरता नहीं है को दर्शाता है। अपचारी अपने भाई की शादी के लिए अवकाश में प्रस्थान किए थे, परंतु बर्खास्तगी के विरुद्ध समर्पित होने अंतिम स्पष्टीकरण में इन्हें अपनी मां की बीमारी का हवाला दिया है, जिससे संबंध में इन्होंने अपने पूर्व स्पष्टीकरण में भी जिक्र किया है, मगर वरीय पदाधिकारी को कभी भी इसकी सूचना नहीं दी है। आरोपित को अपने that he has given very lame excuse for the loans and for earlier 169, then 286, it was total 455 days, and then he for the punishment he preferred appeal, Your Ladyship, in the higher authority before the DIG Chap Ranchi, and in that also it was dismissed after considering the gravity of the offence. It was dismissed before that, and again he for the appeal, and he preferred revision also in the year 6/7/22.
that's
Your Ladyship, in that also it was dismissed before.
By way of rejoinder, my lord, only few things, my lord. I would like to point out from
The nature of
the
allegation
counter
is
of
quite
the department itself, my lord. Kindly see the annexure F series of the counter affidavit filed by the respondent itself. मैंने पेज 42 ऑफ देयर काउंटर एफिडेविट जो हमने एक एप्लीकेशन दिया था संचालन पदाधिकारी को, महोदय निवेदन पूर्वक कहना है कि मैं नंद किशोर आरक्षी नंबर सज्जन सच हजारीबाग का सिपाही पद पे हूँ। महाशय को बताना चाहता हूँ कि मुझे वाहिनी मुख्यालय झारखंड सशस्त्र पुलिस 7 से दिनांक 21/6/18 से 23/6/18 तक के दिन की छुट्टी 2 दिन की छुट्टी प्राप्त थी, लेकिन दिनांक 24/6/18 को मेरी मां, जिनका दिमागी हालत ठीक नहीं है, वो घर से कहीं चली गई थी, जिसकी खोजबीन एवं मेरी मां की इलाज प्रक्रिया के अंतर्गत काफी दिन लग गया। इस बीच जांच पदाधिकारी अवर निरीक्षक दुर्गाचरण बारी मेरे घर आए तो मैंने अपनी आप बीती उनको बताया और इस संदर्भ में आवेदन भी दिया, जिसमें मेरी मां की मेंटल सर्टिफिकेट संलग्न किया, जिसके अनुसार मुझे 16/11/18 को अपने कर्तव्य में उपस्थित होना था, परंतु उस समय भी मेरी उपस्थिति नहीं हो पाई, कारण कि अचानक मेरी तबीयत बिगड़ गई। डॉक्टर जांच से पता चला कि मेरी नाक में अंदर चोट या इन्फेक्शन हो गया है, जिससे मेरे सर में हमेशा दर्द रहता है और जिससे कभी कभी चक्कर भी आ जाता है, जिसकी जानकारी मैंने दिनांक 26/12/18 को रजिस्ट्री पोस्ट के द्वारा वाहिनी मुख्यालय में दिया है। अंततः श्रीमान संचालन पदाधिकारी महोदय से नम्र निवेदन है कि मेरे इलाज से में पूर्ण होने तक सुनिश्चित समय दिया जाए ताकि स्वस्थ होकर अपने कर्तव्य में उपस्थित हो सकूं। इस कार्य के लिए मैं श्रीमान का आभारी रहूंगा। मतलब दी अनदर लेटर written by me, my lord, that is on page that is dated 6/9/19, my lord.
Yeah, that's the document.
Yes, you have annexed, but
given
has not
sufficient
been
opportunity to the
Let
person.
us-
that I am placing. That I am placing. महाशय बताना चाहूँ कि मुझे वाहिनी के काम से 2 दिनों की छुट्टी प्राप्त हुई थी, लेकिन उसी समय मेरी जिनकी माँ की संतुलन ठीक नहीं है वह घर छोड़कर कहीं चली गई, जिसका खोजबीन एवं इलाज प्रक्रिया के अंतर्गत काफी। सो my lord, the repetition I kind of the same kind of the reason, my lord, which was there in the actually, my lord, at my home, because regarding my mental illness of my mother, my lord. So this kind of compelling circumstances is there. The another point, my lord, which I was raising, my lord, there is no specific charge. कोई ऐसा स्पेसिफिक चार्ज नहीं था जिसको आधार
आप
पर
repeat
पढ़
मत
कर
करिए, please.
हाँ बोल रहे हैं, my lord, जो चार्ज में जो पॉइंट था
आप रिपीट मत
286 डे वाला, ठीक है हम उसको रिपीट नहीं, बट एक जो हमने जो एक लीगल पॉइंट जो रेज किया, my lord, these 2 legal point that has not been reverted by my friend, वो जो सेकंड सो कॉल्ड विथ रिगार्ड टू फाइंडिंग्स ऑफ
WPS number 2373 of 2023. Heard the learned counsel for the parties. This writ petition has been filed challenging the order of departmental punishment as contained in memo number 46 dated 22/7/2022 within bracket annexure 4, whereby the petitioner has been dismissed from service. The petitioner has also challenged the appellate order dated 3/11/2021, whereby the appeal has been dismissed, and the petitioner has further challenged the order dated 6/7/2022, whereby the Director General of Police, Inspector General of Police, Government of Jharkhand, has rejected the representation of the petitioner against his dismissal. The learned counsel for the petitioner has submitted that though all the authorities have passed orders against the petitioner, but the impugned orders are perverse. The learned counsel has referred to the charge memo as contained in Annexure 1 dated 27/12/2018 and has submitted that the charge was only in connection with overstay after 2 days leave, that is for 21/6/2018 to 23/6/2018, and there was no charge of any specific days of absence. He has further stated that in the charge memo itself, it has been mentioned that one Durga Charan Bari had gone to find out about the petitioner, and on 29/10/2018, the petitioner had given an application to him that his mother was suffering from mental ailment and was under treatment. And he had stated in that letter that he would join on 16/11/2018. But this aspect of the matter, that the mother of the petitioner was suffering from mental ailment, which was sufficient reason for overstay, has not been properly considered by the authorities while passing the impugned orders.
Excuse me, ma'am.
The
May I take leave, ma'am?
Learned Counsel has
May I take leave? Yeah, my friend.
nahi. No, I will not permit that. I've heard you for 1 hour, you hear me for 15 minutes. Yes. The Learned Counsel for the petitioner has submitted that reason for absence of the petitioner was not willful, and accordingly the punishment of dismissal was uncalled for. The Learned Counsel has referred to the Learned Counsel, while further advancing his arguments, has referred to the inquiry report and has submitted that as per the inquiry report, the medical certificate produced by the petitioner with regard to his illness was not taken into consideration in view of the fact that by stating that the petitioner did not produce the receipt of the medicines purchased and also the wrappers of the medicines. The Learned Counsel submits that the medical certificate issued by the doctor was sufficient to prove the fact that even the petitioner was not well for certain period. The Learned Counsel has further submitted that so far as the second show cause is concerned, the same was not in accordance with law, inasmuch as no specific averment was made in the second show cause asking the petitioner to respond to the inquiry report. Rather, the second show cause simply stated that the petitioner was to respond to the proposed punishment. He has referred to the judgment passed by the Honorable Supreme Court in the case of Managing Director ECIL versus B. Karunakar, reported in bracket 1993 bracket close 4 SCC 727, and has in particular referred to paragraph number 24 of the 25 of the said judgment. The Learned Counsel submits that it is the constitutional right of the petitioner to respond to the inquiry report, and therefore the constitutional right of the petitioner having been violated, the impugned orders cannot be sustained in the eyes of law. The Learned Counsel has referred to the judgment passed by Honorable Supreme Court, reported in bracket 2012 bracket close 3 SCC 178, Krishnakant B. Parmar versus Union of India and another. Paragraph 17, to submit that all cases of absence do not call for punishment. The absence is required to be proved as willful, but in the instant case, there was no willful absence on the part of the petitioner, and therefore the impugned orders cannot be sustained in the eyes of law. वो छूटा आपका सबमिशन?
थोड़ा सा स्मॉल कि वो फाइंडिंग ऑफ फैक्ट्स पे जो इंक्वायरी रिपोर्ट में फाइंडिंग ऑफ फैक्ट्स पे कोई सो कॉज इशू नहीं है। प्रपोज पनिशमेंट तो माय लॉर्ड हैज राइटली
वो तो लिखा दिया, आप सुने नहीं? The learned counsel for the respondents, on the other hand, while opposing the prayer of the petitioner, has submitted that the proceedings in that there are 3 concurrent orders against the petitioner, and there is no perversity or illegality calling for any interference under writ jurisdiction. The learned counsel has also submitted that so far as the allegation is concerned, although it was for overstale, but the petitioner remained absent even after issuance of show cause for a total period of 289 plus 169 days. She has also submitted that the petitioner had taken a plea that for some time he was suffering from nasal infection, right?
Yes, Your
Nasal infection, but the medical certificate produced by the petitioner was regarding a dental problem.
Dental problem.
The learned counsel has also submitted that that mere production of a certificate from the doctor is not sufficient, in as much as neither any document regarding purchase of medicine, nor any prescription of the
Medical
doctor,
certificate.
nor any wrapper of used medicines were produced by the petitioner, and therefore the authority has refused to rely upon the medical certificate submitted by the petitioner by citing reasons. She has submitted that the plea of the petitioner having been considered, the impugned orders cannot be said to be perverse. The learned counsel has further submitted that so far as the plea of the petitioner in connection with treatment of mother is concerned, the document in connection of the year 2009 and 2016 were only produced, and no document for the period involved in the present case was produced in connection with the ailment or treatment of the mother of the petitioner. The learned counsel has further submitted that the second show cause was issued to the petitioner, and the petitioner responded to the same by referring to the findings of the inquiry officer, and the disciplinary authority, after taking into consideration the materials of the inquiry officer, the inquiry report, the plea of the petitioner, and passed the impugned order of punishment. The learned counsel has submitted that the petitioner also filed an appeal, and before the appellate authority also his plea was considered, and appeal was dismissed by citing reasons, and thereafter the petitioner filed his representation, which was also dismissed by citing reasons. The learned counsel submits that the conduct of the petitioner suffers from dereliction of duty and unauthorized absence, and therefore unauthorized absence without any proved justification before the inquiry officer and the respondent authorities, and accordingly the impugned orders do not call for any interference. That's it. Arguments concluded. Post for judgment at date.
Let me come back.
Tenth of June, opening day. June. सौरभ लिख लीजिए, भूलिएगा नहीं, अब एकदम फ्रेश है, लिख लीजिए.
Item 4 WPS 4471 of 2023.
Inspected the old rate, it is there not that document was at page number 69, lecture 8 in the old rate.
Page number
69. Readings to that effect was at para 16 of my rate, also at rejoinder para 8 and
yes. So your case is that you had taken due permission for the purposes of.
Yes, Your Ladyship. And I have applied under non-para category. I am not taking the
It
benefit.
makes no difference. Yes. What you
Because
say?
of why you are saying non-para? Because I have
Lord,
got a document just for it. Which I have annexed in supplementary affidavit under right to information and from the very same authority, Dumka DSC. He said in on the right reply to right to information that गैर para के लिए regular की आवश्यकता नहीं. So I have asked
You
him.
need not, because you are not seeking any kind of benefit,
Yes, benefit from that.
of a para teacher.
Yes.
So it is immaterial whether you have taken any permission or not taken
Yes,
any permission.
that is-
But otherwise also you have taken some permission.
Yes, no,
Give me one judgment which covers your case.
But first the judgment, I would show you
Just
ladyship
one
judgment
judgment should
only.
be sufficient.
Your ladyship judgment suffice because your
Which
ladyship has covered the order of LPA and 2 orders of coordinate bench. Other than this, my lords, I have also.
Which judgment is that?
It is at serial number 7 of my index, WPS 988 of 2020, Mr. Daud Ansari. Start from page 25. See a judgment of a ladyship, and other than that, there is a judgment of LPA court and other coordinate bench of different honorable judges. That there is no
Yes, you
illegality
tell
or
us.
misconduct.
Why his candidature should not be considered?
But as per the infill order passed by the authority, candidate has been considered as per the LPA, order of the LPA. They have simply said that they have in LPA blood, that very petition blood was taken permission from the block education extension officer, BE, and this petition blood has taken permission from the committee only, not by the department. That's why not.
From the committee.
Yes, sir, village education committee. That's why not they have not considered the candidature of the petition. That is the sole ground, I think so.
But in your ladyship,
Annexure E is
We have
the,
considered village education.
yes, your
committee.
ladyship
Yes,
has considered my lord, and actually village education committee is my appointing authority. I am a
That's
para
right.
teacher. I am not a permanent teacher to take the permission from the department.
That's right.
Particularly para 7 and 8 is the findings of your ladyship. Page 27.
And what do you say by regarding his candidature against non-para category? He is not claiming any benefit.
yes, yes, well, I'm
How
not.
does that make a
I'm-
difference?
I'm not on that level.
But he is on that. What do you respond to that? I will record that you have no response to that. I am giving you an opportunity to respond to his argument. that once he applies under non-para category, he is not claiming any benefit of para teacher category.
Then I have
Matter
to,
ends.
then I have to respond to that.
No affidavit is required. You just tell us. No affidavit is required. Thank you. Learned counsel for the parties are present. This counselling is going on. Counselling is
25th.
over.
25th.
Your counselling was done.
My counselling was done. I was selected, my lord. Later on, my candidature was rejected.
So that rejection of candidature is under challenge.
Is under challenge. It was through the Honorable Writ Court has directed to pass a reason order. Reason order is under challenge.
WPS number 4471 of 2023. The learned counsel for the parties are present. The state petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner being a petitioner though a para teacher had applied under non-para category pursuant to advertisement number 1 of 2006 1/06-2015, which was later on modified by advertisement number 4 and 5 of 2015 for the district of Dumka. The learned counsel submits that initially there was a dispute as to whether the candidature of para teacher applying under non-para category could be considered or not. The same was settled at rest by virtue of judgment passed in LPA number 213 of 2018, which was allowed in favor of the writ petitioner by judgment dated 23/7/2018. The learned counsel submits that there has been subsequent counselling by virtue of the orders passed by this court, and by way of last chance, one more counselling is to be conducted from
25th.
25th
Yes.
of this month.
Of this month.
The learned counsel submits that the selection process is not yet over.
Yes.
He submits that the candidature of the petitioner was the learned counsel submits that the petitioner was called for counselling
Yes, ma'am.
but was not selected, and under such circumstances the petitioner filed a writ petition seeking a direction upon the respondents to appoint the petitioner on the post of inter-trained teacher within bracket assistant teacher comma class 1 to 5 under non-para category for the district of inter alia for the district of Dumka. You are only concerned
Only
with
Dumka, right?
yes. The said writ petition was disposed of by the order dated 27/1/2021, passed in WPS number 4581 of 2019, and the respondents were directed to consider the grievance of the petitioner by passing a reasoned order. The said order was subject to certain modification by virtue of CMP number 77 of 2021, disposed of on 3/9/2021. The learned counsel submits that ultimately a reasoned order has been passed, which is contained in impugned memo number 1852 dated 22/7/2023, and the candidature of the petitioner has been rejected only on account of the fact that the petitioner did not seek due permission / no objection from the competent authority for his enhancement of educational qualification
While working as
while working as para teacher. The learned counsel submits that the petitioner had taken due permission from his appointing authority on 16/6/2003 as contained in Annexure 7 series from the
Village Education Committee.
Village Education Committee, who is the appointing authority of the petitioner,
Yes.
and thereafter he has completed the course and enhanced his educational qualification. He has also submitted that otherwise also the petitioner, having applied under non-para category and having not taken any advantage
Yes.
of reservation for para teacher category, the requirement of taking any permission for the purposes of higher education has no bearing in the matter. He has relied upon the judgment passed by this court in WPS number 988 of 2020 dated 24/8/2022 and has submitted that in the said case also the appointing authority, that is the Village Education Committee, had granted the due permission. He submits that in the said judgment, the various other judgments have been
Yes.
considered
Yes, at para 5 also.
at paragraph 5. The learned counsel, appearing on behalf of the respondents while opposing the prayer of the petitioner, has submitted that the appropriate permission was required to be taken from
the block education officer.
From
block extension education officer.
block
Extension Education Officer.
extension education
Yes.
officer and not from the village level committee.
Yes.
And therefore the petitioner is not entitled for any relief. His permission was not in accordance with law. However, with regard to the argument of the petitioner that he had applied under non-para category, the learned counsel for the respondent has nothing to say. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the petitioner, while working as para teacher, had applied under non-para category and has chosen not to take any benefit of reservation made available to candidates who were para teachers and were applying under para teacher category. The learned counsel has further submitted that initially, the fact remains that the petitioner was called for counselling and was found fit and eligible
Yes.
in all respect,
Even obtained higher marks than last selected.
but his candidature was not considered on the sole reason that he had not taken due permission for the purposes of obtaining higher educational qualification. The document contained in Annexure 7 series dated 16/6/2003 and the corresponding paragraph in the writ petition, कहाँ है? Para number?
Number 13, page 14.
Para 13, wherein the petitioner has specifically stated that the petitioner had taken due permission from the competent authority / appointing authority by letter dated 16/6/2023 and had taken admission in Karnpur College, Barkagaon, Hazaribagh for pursuing his intermediate course, which is an affiliated college under Jharkhand Academic Council Ranchi, is not in dispute in the counter activity. This court finds that in the judgment passed by in the judgment dated 24 ये LPR में तो नहीं गया, judgment dated 24/8/2022 passed in WPS number 988 of 2020, the matter regarding seeking permission from the competent authority for enhancing educational qualification has been considered, and the petitioner of the said case had relied upon the judgment passed by this court in LPA number 385 of 2019 and WPS number 2642 of 2018 and WPS number 275 of 2018. In that case, it was Village Education Committee.
Yes, of course. That's very
Any one of these judgments have you placed?
not this one, Lords. 385 is there, Lords. Serial number 1.
385 is
Yes, serial number 1.
just.
26. It was block extension officer, but the ratio of judgment is very clear that enhancing the educational qualification does not have any bearing effect of illegality or any misconduct. And here my case is of non-para category.
In the judgment passed in LPA number 385 of 2019, the findings of the Honorable Division Bench is contained in paragraph 6 and 7, which is as follows. This court finds that the Honorable Division Bench did not find any illegality in the order passed by the Honorable Single Judge quashing the termination order of the writ petitioner on the ground that she had not committed any misconduct so that her service could be terminated, on the ground that she was given permission by the block education extension officer to enhance her educational qualification. In the present case, the due permission was granted by the Village Education Committee, who is the appointing authority of the petitioner, and the statement made in paragraph 13 of the writ petition has not been disputed by the respondents in the complaint.
Lords, I've searched other judgment also which your Ladyship has mentioned. It was Village Education Committee 2642 of 2018.
2642 of
2018 it was Village Education Committee.
Okay, in the 2642,
Yes, Lords.
I'll just note down. In the judgment passed in the case of WPS number
2642 of 2018.
2642 of 2018,
Yes.
it has been held as follows.
Yes.
Right,
Village-
para number?
Para number. Finding is at para number 9. Submissions start from para number 5, 5, 6, 5 to.
I'll just find it out.
Yes.
Okay.
Because like other coordinator-
However, considering this is over and above the fact that the petitioner was an applicant under non-para category, and therefore the petitioner has not taken any benefit of
Yes.
reservation which was available for para teacher category. In view of the aforesaid facts and circumstances, this court is of the considered view that impugned order rejecting the candidature of the petitioner cannot be sustained in the eyes of law, which is accordingly set aside. Who will take the call now?
District education of superintendent or the deputy commissioner?
The respondent number
Yes.
3. The respondent number 3
DC will be there.
is directed to take appropriate steps in connection with the appointment of the petitioner if otherwise the petitioner is found suitable. आपका तो काउंसलिंग हो चुका है ना?
हो चुका है, बस इसी के कारण I'm very much deeply organized.
This petition is accordingly disposed of. The needful be done within a period of 1 week from the date of communication of this order.
Deeply organized.
तो केस का नंबर ठीक से लिख के दे दीजिए ना, नहीं तो छूट जाएगा तो फिर ऑर्डर अपलोड नहीं होगा कौन तक।
Item 65, criminal revision 300 of 2020.
Well, at the very outset in this matter, senior counsel Mr. A.K. Kashyap has been engaged in this. Yesterday night,
Mr.
Mr. A.K. Kashyap, senior counsel Mr. A.K. Kashyap has been engaged yesterday night itself. So I was only praying it may be kept any day in the next week.
Just a minute. Let us start hearing.
Well, he will be assisting your lordship in this matter.
That's right. Let us start hearing the petitioner. He is
Client.
sitting here since so long. We will give you an opportunity. Let me just figure out what is the case. I have not gone through it. इतना 66 item हम पढ़ के नहीं आए. इसलिए रुक
I was
जाइए.
only praying that any day in the next week.
अरे भाई थोड़ा सुनने तो दीजिए, हो सकता है आपकी जरूरत ना पड़े.
My lordship.
Possible?
My lordship.
तो फिर मंडे को अब मंडे को नहीं आपके मुंह से
See, I'll tell you one thing.
नहीं अब तो मैं
जब हम आपसे अभी तो हम पढ़े ही नहीं, हमको पता ही नहीं है.
तो मेरा कॉन्फिडेंस ही शेक कर गया था. अब आप मंडे को रख दीजिए. अब आप मंडे को
थोड़ा समझने तो
Just prior to
देखिए.
starting, my lords, I would like to point out 2-3 things, my lords. Distress warrant has been issued in favor of the against this petitioner, and a sum of rupees 12,60,000 is due till March 2024.
ये एग्जीक्यूटिंग कोर्ट है.
My lords,
We are not concerned.
distress
कोई
warrant.
ऑर्डर था यहाँ से, स्टे या कोई
Stay था.
डायरेक्शन,
There was no stay.
Stay था.
There was no
कोई
stay.
डायरेक्शन था पेमेंट करने का. दिस इज नॉट एन एग्जीक्यूटिंग कोर्ट. डिस्ट्रेस वारंट है, जेल भेज दीजिए, आपको जो मर्जी करिए. वी विल सी ओनली द इम्प्यून्ड ऑर्डर. इम्प्यून्ड ऑर्डर ठीक है तो ठीक, दे तो कोई बात नहीं. ठीक है ना, उसके बियॉन्ड नहीं. आप ऐसे प्रेजुडिस नहीं होता माइंड. आप बोलिए आपको मंडे को करना है,
मंडे को नहीं.
बताइए कब करना. इट इज योर चॉइस.
मंडे को कर दीजिए.
मंडे को नहीं, मंडे इज नॉट द डे.
जब आप
थर्सडे को ही हो.
जब एक I'll just try to remind him there's already an IA application pending before my lords.
No, we will either you start your argument right now. I am ready to hear. If you want
There is
on another date,
there's an IA pending.
कुछ नहीं तो आप बहस करिए, हम तो सुन रहे हैं आपका केस.
आइए.
आर्ग्यू.
आइए.
अरे शुरू करिए ना, शुरू करिए. चलो. Who is the petitioner before this court?
The petitioner is the husband, but the case runs like this, but the petitioner is the husband. He has suffered an order of maintenance amounting to around 25,000 rupees. Now, he filed a revision application as against that particular order passed by the family. Now, when this matter was going on, now one of the coordinate bench decided that both the parties should file affidavit in accordance with Rajneesh versus Neha case. Rajneesh versus Neha case says that you have to file an affidavit
What is
regarding.
the date of the order?
Yes, that date of the order is not. It is 17th of November 2020.
No, 19 to 20.
19 to 20.
19 to 20.
19 to 20 is the date of order.
Yes. By this time, the judgment of Honorable Supreme Court in the case of Rajneesh versus Neha was already pronounced.
No.
No affidavit was filed.
No. Yes.
What is the wife doing?
That is what I'll come to it first. Now this court here mandated that you should file an affidavit before this court.
Filed?
Yes. Now they fight, and she concealed the fact that she is working. Now, as against that, we find.
Therefore, you see, we have passed lot many orders. You don't see our court's order. So many cases have been remanded on this ground. There is a reason for it. We don't want to take evidence in a revisional jurisdiction. That is a matter of evidence only, no? This has to be done. Because if we start taking evidence for the first time in a revisional jurisdiction, where will the either party go against our finding? Yes, Mr. Salish, just tell us. In revisional jurisdiction, is it permissible? Can we do it? Therefore, it has to be remanded.
Yes, yes.
वहाँ एफिडेविट फाइल करिए क्योंकि वहाँ एक फाइंडिंग रिकॉर्ड होगा उसके अगेंस्ट में तो आप बंदा हाईकोर्ट आएगा ना कोई भी पार्टी यहाँ फाइंडिंग रिकॉर्ड कर देंगे तो कहाँ जाएगा क्रिमिनल जूरिस्प्रूडेंस तो हम ऐसे नहीं डिसाइड करेंगे और शो मी सम बेस सीआरएमपी थोड़ी है वॉशिंग 482 आई विल नॉट अप्रिशिएट ऑल दीज थिंग्स हियर बिकॉज जब ये सारे एविडेंस फाइल होगा हो सकता है कोई क्रॉस एग्जामिन करना चाहे कोई भी बात हो सकती है वी कांट डू इट This has to go. There was a clear direction in the case of Rajneesh versus Neha that in all the pending proceedings, this affidavit was required to be filed. Having not filed, it has to be set aside. We can't do anything. बोलिए अभी कर लेते
No, ma'am. Let it come on Thursday.
चल मंडे ये इतना करने के लिए तो हमको कुछ करना ही नहीं है
Thursday.
मंडे सेकेंड हाफ आ जाए इतना ही करना मिस्टर सैलिश यू जस्ट टेल अस यहाँ पे अगर हम कोई फर्स्ट टाइम फाइंडिंग रिकॉर्ड करते हैं
बिल्कुल
तो कहाँ जाएगा
ठीक वो ठीक
बस इतना ही
लेकिन हाँ वो तो है
ठीक है ऑर्डर हो गया आ गया वही चीज आप वहाँ फाइल करिए क्रॉस एग्जामिन करिए जो मर्जी करिए बिकॉज नाउ इफ देर इज अ फॉल्स एफिडेविट वो क्रॉस एग्जामिनेशन में पता चलेगा फिर यहाँ पे 340 का पिटीशन चालू हो जाएगा तो ये सारा प्रोसीडिंग्स हम यहाँ पे रिविजनल जुरिस्डिक्शन में नहीं करेंगे
वही बोल के भेज दिया जाए नीचे हम लोग जाएंगे
तो मंडे को कर देंगे ये तो टाइम मांग रहे हैं आप भी टाइम मांग रहे हैं
नहीं हम टाइम इन द सेंस कि ऐसा आपके मुंह से निकला तो उसके बाद
आप कोर्ट का ऑर्डर्स नहीं देखते आप सोचते कोर्ट को कुछ नहीं पता है
अरे
और कुछ नहीं आता है आप कहाँ देखे ये कम से कम नहीं तो 15-20 ऑर्डर हम ऐसा किए हैं आप देखे ही नहीं आपको पता ही नहीं आप देखते ही नहीं
हाँ ये हम देख लेते आई टेक
और देखिए फ्रॉम द डेट ऑफ पासिंग ऑफ जजमेंट है दिस इज एब्सोल्युटली इन टीथ ऑफ द जजमेंट ऑफ द ऑनरेबल सुप्रीम कोर्ट इट हैज टू बी फ्रॉम द डेट ऑफ फाइलिंग द एप्लीकेशन आपको भी नहीं पता पढ़िए भाई थोड़ा सा पढ़ाइए
वो तो खैर उनका काउंटर वाला है एक और बात था इसमें एक और बात ये हो गई थी कि
देखिए हम यहाँ पे एविडेंस नहीं लेंगे
नहीं उस पे नहीं
सर देखिए बहुत छोटा सा बात हो गया
एक चीज और
देखिए आगे सीनियर हो गया काम सर देखिए आफ्टर द जजमेंट पास इन द केस ऑफ रजीज वर्सेस नेहा in all the proceedings pending proceedings the affidavit was necessarily to be filed that was a direction passed by the honorable supreme court to all the courts
This case.
yes the affidavit in this case before the learned court was not filed there was a direction to file an affidavit here maybe certain affidavits have been filed there are dispute in connection with those affidavits but in revisional jurisdiction for the first time if we appreciate the affidavits and give any finding where will the litigant go इसीलिए ये फाइंडिंग क्रॉस एग्जामिनेशन होगा हो सकता है 340 सीआरपीसी का पिटीशन फाइल हो जाए तो ये सारा काम ट्राई कोर्ट मतलब लोअर कोर्ट में ही होगा यहाँ नहीं हो जो भी आपका एफिडेविट है जो भी कुछ है वहीं पर अप्रिशिएट होगा यहाँ रिविजनल जुरिस्डिक्शन में हम नहीं कर सकते
तो ये इनका कंडन
नहीं यही इसको रिमांड करना है इसी ग्राउंड पर क्योंकि सुप्रीम कोर्ट के ऑर्डर का कंप्लायंस नहीं हुआ दैट इज द मैंडेट आप देख लीजिए आप बोलेंगे तो मंडे को रख लेंगे आप देख लीजिए जजमेंट
But it will be better for me also, just for proper assistance to the lordship. This case may be adjourned for next
Monday.
week, not any
मंडे
day may
मंडे
continue.
मंडे इसी ग्राउंड पर आप इसको देख लीजिए बहुत सारे ऑर्डर्स हमने रिमांड भी किए हैं आप वो भी देख लीजिए दो चीज़ है इसमें जो एपरेंटली दिख रहा है पहला एफिडेविट नहीं फाइल हुआ है दूसरा फ्रॉम द डेट ऑफ जजमेंट है मेंटेनेंस का ऑर्डर The judgment of the Supreme Court
Yes,
says
from
it
the
has
date
to be
of
from the
filing
date
of the
of.
petition.
तो वो आपने तो पिटीशन नहीं फाइल किया, इनके पिटीशन में हम आपको रिलीफ कैसे देंगे?
तो ठीक है, वो हम तो भी ये हैं कि इसमें
इसीलिए फ्रेश ऑर्डर होगा दोनों का।
फाइल कर ही सकते हैं उसके लिए
कुछ नहीं, ऐसा नहीं हो सकता है, वो हम नहीं कर
अभी
सकते।
तक एक पैसा ये जमा
सर
नहीं होता
देखिए,
है।
हमारा ये कोर्ट एग्जीक्यूटिंग कोर्ट नहीं है, हम एग्जीक्यूशन नहीं करेंगे। एग्जीक्यूशन आपको यू हैव योर रेमेडी। अगला बंदा बोले हम 1 महीना जेल में रहने को तैयार हैं।
नहीं, इसमें
बोल
हम
सकता है
लोग फाइल
कोई?
किए हैं,
कोई
डिस्ट्रिक्ट
बोल
वारंट
सकता है
किए
ना?
हैं,
हाँ।
डिस्ट्रिक्ट वारंट से फाइल किए हैं, लेकिन ये है क्योंकि यहाँ पेंडिंग है इसलिए वहाँ पर कोई कार्रवाई नहीं होती।
नहीं कुछ नहीं, आप मंडे को फाइनल ऑर्डर
स्टे
करते
है, देयर इज अ स्टे,
अच्छा,
कंटेम्प्ट एक स्टे है यहाँ पे।
Criminal Revision number
Stay
300 of
vacating one.
2020. The learned counsel for the parties are present. भाई अपना अपना appearance दीजिए। The learned counsel for the petitioner has submitted that the mandate, the directions of the Honorable Supreme Court in the case of Raziz versus Neha was not complied before the learned court, and therefore, by virtue of order passed by this court, appropriate affidavit.
We have complied, but certain
No,
issues
no,
have come
before
up
the
that-
court.
बिफोर द कोर्ट
वहाँ तो नहीं कंप्लाई हुआ ना? क्या
हम
पूछ
देख
रहे
लेंगे,
हैं?
हम इनका भी पता नहीं।
अच्छा छोड़िए, आप लोग को पता ही नहीं। दोनों का अपीयरेंस रिकॉर्ड करिए, मंडे को पोस्ट कर दीजिए at 15।
हम तो कल ही भी एंगेजिंग में इसलिए हम सब पढ़े नहीं हैं, इसलिए
पढ़िए।
हाँ।
दूसरा बात है ये जो कह दी है स्टे ऑर्डर होने के बाद कैसे हाउ द कोर्ट मस्ट वेकेटेड
कोई
द स्टे।
बहुत कंफ्यूजन था ना,
आपका
एशियन
district warrant का मतलब ये
रिसर्फेसिंग
district
वाला
warrant
केस को बहुत तरह का
stay हुआ है।
प्रॉब्लम
That's
था।
over. Now that is
Execution
over.
of the order has not been stayed, only district warrant issued against him, that was stayed.
We are not
How
on that.
the-
We
how
will
the-
finally decide the case on Monday. आप आ जाइए 2:15 बजे।
Same meeting.
For final disposal to be taken up as the first case.
Thursday को अगर आपसे बोला था,
अच्छा ठीक है, थर्सडे कर।
Thursday बंद।
थर्सडे बंद
नहीं, 10th को
खुला है।
बाद
Thursday तो
15th को
15 को हम दूसरा केस रखे होंगे, ये केस नहीं कर सकते।
16
मंडे को छोटा सा मैटर है सर।
छोटा सा ये पूरे पढ़ना होगा, बड़ा लंबा इनका है, अब तो हम देखे ही नहीं तो हम कैसे बोले।
अब आप सुप्रीम कोर्ट का ऑर्डर का कंप्लायंस ही नहीं हुआ है तो क्या पढ़िएगा?
नहीं हम तो
आप हमको बताइए, जब सुप्रीम कोर्ट ने ऑर्डर पास कर दिया कि सारे पेंडिंग केसेस में मैंडेटरीली फाइल करना है,
अब ये देखना पड़ेगा थोड़ा सा कि लोअर कोर्ट में हो सकता है कि चांस मिला हो, मैंडेटरी लोग नहीं, दोनों ही पार्टी नहीं कंप्लाइंट की हो।
तो आप देख लीजिए ना, रिकॉर्ड तो यहीं पर है, एलसीआर तो आया हुआ।
उसके बाद हाई कोर्ट का ऑर्डर हो गया न्यायाधीश रजनीश का यहाँ पे फाइन करना, वहाँ पे इन्होंने गलती
यहाँ पे हम नहीं अप्रिशिएट करेंगे,
whatever it is
यहाँ पे हम पहली बार में नहीं
that's a
यहाँ पे
separate
फिक्स
issue.
करेंगे।
That's why I said okay. That's why I said कि ठीक
आप
है।
बताइए मंडे ट्यूसडे जब बोलिए,
15 तारीख को दिया है,
15 तारीख को नहीं,
16 को दिया
15 को 10:30 बजे एज फर्स्ट केस,
15
दैट इज
को।
पॉसिबल। 15
15 को।
ठीक है, चलिए। आप लोग अपना मेमो ऑफ अपीयरेंस दे दीजिए, नहीं तो किसी किसी का नाम छूट जाएगा, फिर नेट लॉस आप ही लोग को होने वाला है।
Item 12, criminal revision 267 of 2019.
Matter next to 138 compromise are already in place.
हो गया? कहाँ है जॉइंट कॉम्प्रोमाइज?
6-2
सप्लीमेंट्री एफिडेविट
सप्लीमेंट्री ज्वाइंट compromise दोनों पार्टी का
कहाँ है जॉइंट कॉम्प्रोमाइज? पढ़िए, कितना का चेक था?
50,000 का हुआ था कंपनसेशन, 50,000 दे दिए हैं, लेकिन सिंस द अपील वाज डिसमिस्ड ऑन द ग्राउंड ऑफ लिमिटेशन दैट एफिडेविट वाज नॉट कंसीडर्ड बाय द कोर्ट। इस समय उसी समय जमा हो गया था, ये पेज हमारा 9 पे है, ये दे भी लिए
तो
थे
चेक अमाउंट वाज 50,000 ओनली।
50,000 और चूंकि जमा भी हो गया था उसी समय ड्यूरिंग डिपेंडेंसी ऑफ द अपील, बट द अपील वाज डिसमिस्ड ऑन द ग्राउंड ऑफ लिमिटेशन, देयरफॉर इट हैज नॉट बीन कंसीडर्ड।
The learned counsel for the parties are present. This petition has been filed. Prayer court. The learned counsel for the petitioner and opposite party number 2 have jointly submitted that a joint compromise petition has been filed in the present case. They have submitted that the matter has been settled out of court. And the opposite party number 2 has received an amount, a check amount of rupees 50,000 from the petitioner. The learned counsels jointly submit that they have no grievance against each other, and therefore this petition be disposed of in terms of the compromise. The learned counsel for the state has submitted that he has no objection to the prayer, as the offence under section 138 of Negotiable Instruments Act is a compoundable offence. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, and that the matter has been settled out of court, and a joint compromise petition has also been filed before this court, this revision is disposed of in terms of the compromise, and consequently the order of conviction of the petitioner by learned judicial magistrate first class in case number C37/2012 TR number 629 of 2017 is hereby set aside. बस लिखिएगा, the learned counsel for the parties have jointly submitted that the conviction of the petitioner be also set aside.
Order in appeal may also.
Order in appeal अब क्या बच गया उसमें?
नहीं तो नीचे का तो क्वेश्चन हो, लेकिन ऑर्डर अपील में तो नहीं जाएगा.
ऑर्डर तो लिमिटेशन में
लिमिटेशन पे हुआ, that is not on merit.
क्या होगा उससे?
लिमिटेशन पे हुआ.
The appellate order is also accordingly set aside. ठीक है, इनका दोनों का सबमिशन लिख लीजिएगा. They jointly submit that the judgment of conviction passed by the trial court and the appellate court judgment be also set aside. यही है आपका.
Item 13, criminal division 739 of 2019.
The petitioner had filed the application for discharge. The airport that was rejected. And against that order, they filed this criminal division. The case was registered under section 306 IPC. There was the case of the person that the deceased that had committed suicide in the hotel where he was employed as a cook. From the pocket of the deceased, it is the case of the person, one suicide note was recovered. On the basis of which the petitioner and his wife have been made accused in this case.
You are the owner of the hotel.
No, I am not the owner of the hotel. The allegation against
Where
me
is opposite party? Notice has not been issued so far.
FIR is a police case therefore.
फिर भी इन्फॉर्मेंट को ही सही पार्टी तो बनाते हैं, नहीं बनाते हैं?
बनाते हैं, but as per the order of the honorable court. Because Lord, we make Lord the complainant as a party in a complaint case.
That's right.
But so far when the police is concerned, if my lord is of the view that notice should go, certainly will make the informant as a party respondent of the party involved.
Let us see your case. What is it? What is your point?
Now the point is that as per the case of the prosecution, the deceased had given allegedly rupees 4,90,000 for investment in brick clean business without any cheat of it. And it is further alleged that the deceased had paid this amount to the petitioner, the husband and wife, without disclosing this fact to the family members. Secretly, he had given. This is the case. But when this money was demanded back, that was not given by the petitioner. Therefore, he said that the deceased has committed suicide. Now the question arises, as per my lord, I have been pleased to call for the case diary also, that in the case diary nothing has come that in fact this amount was given to this petitioner by the deceased, number one. There is no eyewitness, there is no documentary evidence to support that even a single penny was given to this petitioner by the deceased. Thirdly, that mere suicidal note is not sufficient to constitute the offence under section 306 IPC. So far, 114A Evidence Act, there is presumption. If the married lady commits suicide in the matrimonial house, then it can be presumed legally that within 7 years if she commits suicide, then it will be presumed legally that abetment was done by the husband, or the allegation of abetment was committed by the husband or the relatives of the husband. But here it is not the case of the suicide committed by the wife. Now, my lord, there are three things, and my lord was pleased to call for the case diary to verify as to whether any evidence is there regarding payment of money. Because under
Where is the
to
suicide
constitute
note?
the offence under section 3
Suicide note दिखाई.
306 के लिए जो 107 IPC का abetment है defined under 107 IPC. Explanation 1, explanation 2, and the ingredients. Unless until this section 107 the ingredients are fulfilled, no case is made out prima facie under 306 IPC.
Yes, please read it.
केस डायरी मैं इसमें अपना बीटी लिख रहा हूँ। मैं चालाक होकर भी बहुत बुद्धू का काम किया गया। लोग अपना पैसा अपना अकाउंट में रखता है, परंतु मैं अपना गांव के ही दिनेश रवानी मामी कौशल्या देवी से विश्वास किया। दिनेश रवानी के निजी और आपके भैया बिना पर कुछ बिजनेस के लिए बैंक से ज़्यादा मुनाफा होगा। मैं जब भी काम करके घर जाता था तो दिनेश रवानी के घर घुस कर पैसा दे देता था। देते देते लगभग 5 लाख हो गया। हिसाब किया तो 4,90,000 लगभग 5 लाख हो गया। हिसाब किया तो 4,90,000 रुपया हो गया। इसमें से शादी में 1,000 रुपया बाराती में भाड़ा के देने बोले थे। शादी से पहले हम बोले मेरा सारा पैसा दे दो, तो उसने बोला अभी लेके किया करोगे, सारा पैसा तेरा शादी में खत्म हो जाएगा, मेरे पास रहने दो, शादी के बाद हिसाब कर मुनाफा के साथ दे देंगे। पैसा देने से पहले हम पूछे तो किया कि बिजनेस में लगाओ, तो उसने बोली थी ईंट पहाड़ में बहुत फायदा होता है, तेरा पैसा डबल हो जाएगा। तो मैंने सोचा इससे ज़्यादा और क्या फायदा। शादी के 1 सप्ताह बाद मैंने बोला मेरा पैसा हिसाब करके दे दो। तो दिनेश बोला क्या प्रूफ है कि तुम हमको पैसा दिया है। इस बात को सुनकर मेरा होश उड़ गया। तब से आज तक मेरा होश पूरा हुआ है। मैंने डबल फायदा सुनकर आदमी से पैसा लिया है, उसको भी नहीं दे पाया, मुझे लोग तंग करता है। मैंने बहुत आदमी से कर्जा भी लिया, इससे रिश्तेदार शामिल हैं। उन किराना दुकान में मेरी माँ से पैसा लेते थे। मेरी माँ बार बार पूछती थी, तुम हमसे पैसा लेते हो, तुम्हारा बस घर में पैसा लेते हो, तुम जमा करते हो, पैसा करेंगे। सबको बोला आरडी में जमा करता। जब मुझे होश आया कि मैं अपना घर का भी पैसा झूठ बोलकर सारा दिनेश को दे दिया, तो मुझे जीने का मन ही नहीं करता। सारे जहां से अच्छा माँ बाप। हम दिनेश से गुप्त में ही मिलते थे और गुप्त में ही पैसा देते थे, उसका नंबर तक अपना पास नहीं रखते थे। इसलिए क्योंकि उसने बोला था कि तुम हमको किसी के पास पैसा नहीं देना, तेरा घर में भी नहीं बताना, नहीं तो तेरा घर वाला पैसा नहीं देने देगा। क्योंकि मेरा घर में बोल रहा था
सर
कि
इस स्टेज में नहीं आपका केस much is to be proved. It is absolutely a matter of time.
Melody, so far this
Abetment ka indication
suicidal
hai.
note is concerned that is not sufficient. The Supreme
That
Court
is
has
not
also
sufficient. But I will not appreciate a suicidal note and give a finding over there.
Even the Supreme
It is for
Court-
the trial court to
Yes.
say.
Suicidal note.
आपने दो जजमेंट पे रिलाई किया था, वो
दो
दोनों
जजमेंट के अलावा एक और जजमेंट है सुप्रीम कोर्ट का, that the prosecution was quashed at the very initial stage. That is reported in 2006 volume 1 Eastern Criminal Cases page 30. Because the only suicidal note is not sufficient to convict any person. And so far suicidal note is concerned,
Eastern criminal cases.
page 32.
Yes. Can you please?
Paragraph 6 is important.
Yes.
Paragraph 4 that decides the person case. Para 6. In the suicide note, except referring to the name of the appellant at two places, there is no reference of any act or incident whereby the appellant herein is alleged to have committed any willful act or omission or intentionally aided or instigated the deceased Pranab Kumar so and so in committing the act of suicide.
यही तो है.
This is the point which is upon which I
यही
want
तो
to
है आपके
place
केस
my
में.
reliance.
उतना वो इंग्रेडिएंट है.
वही ingredient है जो हम बताना चाहते हैं. Manual Back IDC 306.
Right.
IPC.
Thank you, sir.
Abatement of suicide. If any person commits suicide, whoever abates, the word is abates, the commission of such suicide shall be punished with imprisonment of either dismissal for a term in extent to 10 years and shall also be liable to fine. So abatement, what is abates? That is what abatement that has been defined under section 107 IPC. And there is no legal presumption. There is no presumption clause in the Evidence Act. 107, abatement of a thing. A person abates the doing of a thing who first instigates any person to do that thing. There is no averment in the suicidal note that the deceased was instigated by this person to commit suicide. That was the first clause that goes. Now the second. Secondly, engages with one or more other person or persons in any conspiracy for the doing of that thing if an act or illegal omission takes place in pursuance of that conspiracy and in order to the doing of that thing. Second is talks about the conspiracy. If one poor person or more than one person has the conspiracy for doing that act, meaning thereby for commission of suicide, there is no such ingredient in the suicidal note. That is the only thing against me. Thirdly, intentionally aids by any act or illegal omission the doing of that thing. That is also not there in the suicidal. Explanation 1. A person who, by willful misrepresentation or by willful concealment of a material fact which he is bound to disclose, voluntarily causes or procures or attempts to cause or procure a thing to be done is said to instigate the doing of that thing. There is nothing in the entire case. Then explanation 2. Whoever either prior to or at the time of the commission of an act does anything in order to facilitate the commission of that act and thereby facilitate the commission thereof is said to aid the doing of that act. Where is the case of facilitation? There is no averment in the suicidal note. During the course of investigation, several persons have been examined under section 161 CRPC. None of them has stated that in fact the money was given in his presence or there is any sheet of paper that money was given to the petitioners. There is no such proof. Kindly see note the suicidal note, he says about, he has disclosed the name of 2 persons. Two persons were named. Hiralal Mato, केवल रजक हीरालाल मातो हम ब्याज से पैसा लेकर दिनेश को दिए शिव शक्ति के 15,000 3 persons were named केवल रजक हीरालाल मातो and शिव शक्ति. None of these 3 persons whose names have been mentioned in the suicidal note that he had taken money from them and thereafter he had paid this money to the petitioners. None of these 3 persons have been examined by the police under section 161. This is the course of investigation. So, except this suicidal note, there is nothing in the entire case there. Now, on the basis of suicidal note only, the person cannot be convicted. Of course, my lord may say that the judgment has been passed in the Supreme Court after the conclusion of the trial. But so far the present case is concerned, that is 2006 Volume 1 Eastern Criminal Cases, the Supreme Court has laid down the paragraph 6 is important. May I read again?
पढ़ लिए तो अभी तो आप पढ़े इसको पूरा
हाँ तो पूरा नहीं तो complete नहीं.
हम पूरा पढ़ लिए.
In the suicide note, except referring to the name of the appellant and at 2 places, there is no reference of any act or incident whereby the appellant herein is alleged to have committed any willful act or commission or intentionally aided or instigated. There are 2 acts meant: the aid, intentionally aided or instigated the deceased Pranav Kumar Das in committing the act of suicide. There is no case that the appellant has played any part or any role in any conspiracy which ultimately instigated or resulted in the commission of suicide by the deceased person. Now, paragraph. Apart from the suicide note, there is no allegation made by the complainant that the appellant herein in any way was harassing his brother Pranav Kumar Nar. The case registered against the appellant is without any factual foundation. The contents of the alleged suicide note do not in any way make out the offence against the appellant. After perusal of the suicidal note and after perusal of this section 306 as well as 107 IPC, there is no foundational fact to prima facie attack section 306 IPC. This has been laid down by the Supreme Court at paragraph 7. And further the Supreme Court says, the process initiated against the appellant would only result in severe harassment to the appellant without any fruitful result. In our opinion, the learned single judge is seriously erred in holding that the first in-person report against the appellant disclosed the elements of a causal offence. There was absolutely no ground to proceed against the appellant. Herein, we find that this is a fit case where the extraordinary power under section 482 of the Code of Criminal Procedure is to be invoked. We quash the criminal proceeding initiated against the appellant and accordingly allow the. So this FIR was and the entire process and proceeding were quashed by the Supreme Court at the very initial stage. So, my lord, in this case also, even in the case diary, I will not repeat the same argument, but in the case diary also, except, my lord, there is no, except suicide, there is nothing. Now, my lord, the suppose without the, I assume for the sake of argument that suicidal note is written by the deceased, though this fact has not been mentioned in the case diary, and there is no report of FSL to show that in fact this letter was, suicidal note was written by the deceased himself. I am not on that. Even though I assume that the suicidal note was written by the deceased himself, even then, no case is made out of abetment as defined under section 107 IPC. So, my lord, on the basis of this suicidal note, the order which has been passed by the learned trial court, that is liable to be set aside. And
The investigation is continued.
no, charge sheet
Yes.
is submitted.
Charge sheet must have been submitted, but
Charge sheet.
investigation is continued.
Investigation.
Yes, maybe some other against other persons.
No, there are 2 persons only.
No.
Huh?
पुलिस महानिरीक्षक अपराध अनुसंधान झारखंड के द्वारा अपने ज्ञापन के माध्यम से निर्देश किया गया है कि जिन अभियुक्त के विरुद्ध माननीय न्यायालय द्वारा नो कोर्सिव एक्शन लगाया गया है उनके विरुद्ध आरोप पत्र समर्पित करने की बाध्यता नहीं है। ऐसी स्थिति में कान में अधिक दिनों तक लंबित रखने की कोई औचित्य नहीं है और समर्पित ऐसा कुछ है क्या? यस, charge has also been framed. Charge has been framed now.
But if the order, impugned order, whereby application of discharge has been rejected, if that goes, then the
Charge
entire
has been framed also, and the stage is all at evidence also.
Okay. देखिए, criminal revision number 739 of 2019.
is in position to say whether charge is framed.
Yes, it is at the stage of evidence.
Yes.
When was it framed?
Also, charge has been framed on 18/12/19 also.
18/12/19. It is at the stage of evidence. Any
Proceeding
witness
was still-
examined? Any witness examined?
Also, with
I can't hear.
Proceeding was stayed by this only court.
Jameen or not, but the charges have been framed on 18/12/19 also. And the name of this petitioner has come in the society law.
That's right. We'll
Yes,
see
that
that.
is there, that I have.
We have
not-
seen that, yes.
I have
Okay.
already placed.
Heard the
But
learned
so far
counsel for the
further
parties.
investigation is concerned, my lord,
We'll see.
I think that there
That is a material. Criminal revision number 739 of 2019. Heard the learned counsel for the parties. This revision is directed against the order dated 14/5/2019 passed by learned additional sessions judge Roman 12 धनबाद होना चाहिए, धनबाद होना चाहिए
हाँ,
ना,
धनबादी।
Dhanbad in sessions trial number 122 of 2019 arising out of Dhanbad PS case number 58 of 2019, whereby the petition filed under section 227 of CRPC seeking discharge has been rejected. The learned counsel for the petitioner has submitted that apart from the fact that name of the petitioner has been mentioned in the suicide note, there is no other material on record against the petitioner. The learned counsel has also submitted that merely on account of mention of name in the suicide note is not sufficient to even indicate any action to constitute abetment, and accordingly the discharge petition refusing to accordingly the impugned order refusing to discharge the petitioner for offence under section 306 of IPC is not sustainable in the eyes of law. The learned counsel submits that section 306 of IPC is required to be read with section 107 of the IPC, and the basic ingredient for constituting abatement under section 107 is totally absent, and therefore no offence ex facie is made out under section 306 of IPC. He submits that this aspect of the matter has not been properly considered, and accordingly the impugned order calls for interference. The Learned Counsel has relied upon the judgment passed by the Honorable Supreme Court, reported in 2006 within bracket 1 bracket close Eastern Criminal Cases 33 within bracket State of Tamil Nadu versus S.A. Raja, paragraph. नहीं ये वाला नहीं है.
ये भी
Not this judgment.
2017
2006 within bracket 1 Eastern Criminal Cases 32 within bracket SC. Nitai Datta versus State of West Bengal.
and two other judgments also, on the last
दूसरा दोनों जजमेंट तो कहाँ है बताइए.
वो लिख दिए थे 2017
तो प्लेस नहीं किया हम नहीं जानते.
नहीं प्लेस किए थे लास्ट टाइम.
लास्ट टाइम का अभी तो हम सुन रहे हैं
हाँ,
आपको.
अगर-
लास्ट टाइम सिर्फ आपने रेफर किया था.
हाँ, refer
प्लेस
किया.
तो नहीं कर रहे हैं अभी.
नहीं प्लेस कर रहे हैं.
हाँ करिए. Paragraph 5, paragraph 6. To
Paragraph
submit that the Honorable
and-
Supreme Court has been pleased to quash the entire criminal proceedings,
including the FIR.
including the FIR, and it has been observed that although there was a suicide note in the said case, a suicide note of the deceased in the said case. बताइए कौन सा दूसरा जजमेंट?
And दूसरा जजमेंट है गुरुचरण सिंह 2017 1 SCC page 433.
Para number?
433.
Para,
गुरुचरण सिंह versus State of Punjab.
para
Paragraph 18 and 29.
18 and
29. It is so, Lord, that describes the entire Lord, the verbatim of the suicidal note. Paragraph 18. And
जजमेंट हम नहीं मिलेगा तो हम कैसे ऑर्डर लिखाएंगे?
18 and 29.
The Learned Counsel has also relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2017 bracket close 1 SCC 433 Guru Charan Singh versus State of Punjab, and has referred to paragraph 18 and 29 of the said judgment to submit that the suicide note has been quoted in para 18 of the said judgment, and in spite of suicide note, the judgment of acquittal was passed by the Honorable Supreme Court. यही है?
जी.
और बताइए.
Another judgment code is 2019.
The Learned Counsel has also relied upon judgment passed in the case reported in bracket 2019
SCC page 315.
3 SCC 315. Party name?
M. Arjunan versus
A. Arjunan versus State.
Paragraph 6.
Paragraph 6 of the said judgment to उसमें भी after trial था.
ये दोनों केस आफ्टर ट्रायल का है.
To submit
लेकिन ये
that
first case था
the
वो-
Honorable Supreme Court in the said case has acquitted the convict by holding that the basic ingredient for abetment was not satisfied.
Suicidal note was only considered. And
Suicidal note था उसमें?
हाँ, so
अच्छा,
दोनों-
in that case also,
हाँ,
the suicidal note was involved. The Learned Counsel appearing on behalf of opposite party number 2, informant, on behalf of the informant has opposed the prayer and has submitted that the basic ingredient for abetment is present in the suicide note itself. He has also submitted that the impugned order is a well-reasoned order and does not call for any interference. The Learned Counsel has also submitted that at the stage of discharge, only prima facie case is to be considered, and the matter cannot be considered as by way of conducting a mini trial in revisional jurisdiction. The Learned Counsel has also submitted that the charge has already been framed by the learned court on 18/12/2019, and the matter is at the stage of evidence. The learned counsel appearing on behalf of the opposite party state has also opposed the prayer and has produced the case diary and has submitted that acts and omission of the petitioner has been mentioned in the suicidal note, and therefore no case for setting aside the impugned order has been made out by the petitioner. यही आपका?
No.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the matter relates to a suicide of a hotel employee, namely Ashish Modak, on 9/2/2018 in Vasundhara Hotel of Hirapur, Dhanbad, and a suicide note was said to have been recovered in writing from the possession of the deceased at the place of occurrence. And in the suicide note, disclosure was made that on various occasions he paid a total amount of rupees 4,90,000 to the petitioners in the name of running a partnership, Brick Bhatta, and the amount was not returned to him on demand. And ultimately the FIR was instituted and charge sheet was submitted against the petitioners under section 306 of Indian Penal Code. This court, a copy of the case diary produced by the state refers to has quoted the suicide note at paragraph 5 of the case diary, and upon perusal of the suicide note, it appears that the allegation has been made against the petitioners and the mental state of the deceased on account of act and omission of the petitioner also reflects from the suicide note. This court is of the considered view that at this stage it is sufficient if, at the stage of discharge, it is sufficient if a prima facie case is made out and the learned court does not conduct a mini trial by the learned court was not supposed to conduct mini trial by interpreting, by referring to the suicide note and other materials. This is sufficient to observe that the learned court has passed the impugned order refusing to discharge by citing reasons. This court has the reasons of the learned court is quoted as under. This court finds that the learned court below, the learned court has passed a reasoned order and the same does not call for any interference in revisional jurisdiction, as there is neither any illegality nor any perversity nor any material irregularity in the impugned order. so far as the judgment passed by the Honorable Supreme Court in the case of Nitai Datta bracket Supra is concerned, in the said case, the contents of the suicide note has been referred in paragraph 6, and in the suicide note, except that the name of the appellant before the Supreme Court was mentioned at 2 places, but there was no reference of any act or incident whereby the appellant was alleged to have committed any willful act or omission or intentionally aided or instigated the deceased to commit suicide. This court finds that the said judgment,
In that judgment, in paragraph 4, the allegation and the act committed by this Nitai Datta was mentioned. Allegation was there in paragraph 4.
this court is of the considered view that in the instant case, there are certain acts and omissions of the petitioner mentioned in the suicide note, which the deceased claims to have affected his mental state, has disturbed his mental state. This court is of the considered view that at this stage, the judgment passed by the Honorable Supreme Court reported in this court is of the considered view that the judgment passed by the Honorable Supreme Court in the case of Nitai Datta does not help the petitioner in any manner, considering the suicide note involved in the present case. So far as the other 2 judgments are concerned, which has been relied upon by the petitioner, the same were judgments of acquittal after full-fledged trial, and they were the judgments of conviction, the judgments of acquittal passed by the Honorable Supreme Court, which went to the Honorable Supreme Court after full-fledged trial. And the stage in the present case is, in the impugned order, is that of discharge. And therefore, essentially, the nature of scrutiny of the materials is totally different. In such circumstances, the aforesaid judgment, which has been, the aforesaid 2 judgments reported in bracket 2017, bracket close 1, 433 and bracket 2019, bracket close 3 SCC 315 also does not help the petitioner at this stage of the case. Accordingly, in view of the aforesaid facts and circumstances, there is no merit in this revision application. Consequently, it is dismissed. However, it is observed that, it is made clear that the observations made by this court with regard to the suicide note or any other observation is only for the purposes of considering the legality, validity or irregularity of the impugned order, and any such observation made herein above will have no bearing in the trial, and it will be open to the petitioner to raise all the points before the trial in accordance with. इसको थोड़ा रख के कुछ करेक्शंस होते हैं, ऐसा नहीं है कि सेम टू सेम आपको मिलेगा, बट मोटा मोटी नहीं करेक्शन इसलिए भी ये बोलना ज़रूरी होता है मेरे लिए, क्योंकि ये सारा रिकॉर्डेड प्रोसीडिंग्स है।
खाली 2006 का जो है ना, उसमें
हम देखेंगे हम उसको, क्योंकि वो उतना ध्यान से नहीं देख पाए हैं, तो जजमेंट में थोड़ा एडिशन होगा।